What is a data protection impact assessment? It is an assessment tool to identify privacy risks, foresee problems, mitigate data protection risks of a project. When must a controller and/or processor do a DPIA? Prior to the envisaged processing. Is the DPIA mandatory? Yes, when processing operations are likely to result in high risks to the rights and freedoms of individuals. High-risk processing operations include systematic and extensive evaluation of personal aspects, which is based on automated processing and which produces legal effects or significantly affects an individual, including profiling, processing special categories of personal data on large scale, systematic monitoring of publicly accessible area on large scale. Consult the guidance on high-risk processing operations available on the DPIA's website to evaluate high risk. Examples of high-risk processing operations: the systematic monitoring of individuals' online buying history and behavior for targeted advertising. An intelligent video analysis system that recognizes car number plates to monitor driving behavior in the city. How can a controller and/or a processor do a DPIA? The process is as follows. Describe the nature, scope, context, and purposes of the processing. Check that the processing is necessary for and proportionate to the purposes. Identify and assess risks to individuals with respect to likelihood and severity. Identify measures to mitigate risks. The Data Protection Impact Assessment form, available on the DPIA's website, with a guide on how to complete each section of the DPIA form. Prior authorization and consultation from the Data Protection Office. The controller or processor must seek authorization and consult the Data Protection Office prior to processing personal data in order to ensure compliance of the intended processing with the DPA and, in particular, to mitigate the risks involved for data subjects where the controller or processor cannot provide for the appropriate safeguards required for the transfer of personal data to another country. Transfers of personal data outside Mauritius. A controller or a processor may transfer personal data to another country where the below conditions have been met. There are proof of appropriate safeguards, or explicit consent from data subject, or contract with the data subject, or public interest as provided by law, or legal claims, or vital interests of the data subject, or compelling legitimate interest of the controller or processor, or public register containing information which are required to be transferred. Before effecting any transfer outside Mauritius, you should identify the circumstances, that is, all conditions in which personal data are transferred to recipients located outside Mauritius. You should inform data subjects of eventual transfer. You should implement appropriate safeguards for the transfer with respect to the protection of the personal data. For high-risk transfer, you should conduct a DPIA and ask authorization from the Commissioner. Where you cannot provide for appropriate safeguards or cannot rely on the exceptions provided in Section 36, subsection 1. If you have any queries regarding data protection, contact the Data Protection Office for advice.